In Chapter 8, we'll look at contractual capacity, legality, and enforceability. Contractual capacity is the legal ability to enter into a contractual relationship. A person who is determined by a court to be mentally incompetent can't enter into a valid contract. In other situations, the capacity may exist, but the contract isn't legally binding. We'll take a look at those situations. Minors can enter into contracts. Generally, at the age of 18, a person is emancipated and has the legal capacity to enter any contract that an adult can. However, a contract entered into by a minor is voidable at the option of that minor and can be disaffirmed. Disaffirm means to avoid a contract. The majority rule is that the minor has an obligation only to return the goods or other consideration subject to the contract, provided the goods are still in the possession of the minor. The minority rule is that the minor must restore the adult to the position held before the contract was made. In other words, most states don't require the minor to make the other party whole, just to return whatever they have left. There are some exceptions. Generally, a minor can disaffirm a contract even if they misrepresent their age. However, there are some states that prohibit disaffirmance and hold the minor liable once the minor commits fraud by misrepresenting their age. Contracts for necessaries, things like food, clothing, and shelter, a minor could avoid, but somebody will be held responsible for it. A contract could be ratified. Ratified means to go ahead with a contract instead of avoiding it. And the author says it occurs when a minor on or after reaching the age of majority. Well, technically, they would no longer be a minor. So a minor who enters into a contract can ratify it once they reach the age of majority or for a reasonable period of time afterwards. And that could be express or implied. They could say that they don't wish to avoid the contract, or they could impliedly ratify it by just staying in it. Generally, parents don't have a liability for contracts entered into by minors unless they were required to co-sign. Intoxicated persons could avoid a contract if they lack capacity at the time the contract is made. If they still have the capacity to understand what they were doing, it would be valid. One thing they could do is, after they sober up, they could decide they want to remain in the contract. So voidable means at the option of the person who was intoxicated at the time. If a person has been determined to be mentally incompetent by a court and a guardian has been appointed, then any attempt for them to enter into contract is void. If the person hasn't been declared to be incompetent by a court but does lack the mental capacity at the time they enter into a contract, the contract is voidable. If they did understand the nature and effect of the contract, then the contract is valid. Sometimes this could be depending on the person's mental state. In other words, if they have a lucid interval, if they understand what they're doing, it would be valid. If at the time they lack the capacity, then it would be voidable. Look at the legality of a contract. For a contract to be enforceable, it must be for a legal purpose. You could have a clause in the contract that's illegal, but the rest of the contract could be legal and enforceable. A contract to commit a tort or crime would be illegal. Contracts contrary to statute. If there's a federal or state law that prohibits something, you can't contract to do it, and it would be void. In other words, it would be not a contract from the start. Usury, which means charging an excessive interest rate above the law, would not be enforced. Gambling would be another example of a contract that wouldn't be enforced unless, of course, it's sanctioned by the government. and licensing statutes. Attempt to enter into a contract without proper license could affect the enforceability of the contract. If the purpose of the licensing statute is simply to generate revenue, generally the courts will give a remedy. However, it's to protect the public safety, for example, licensing for attorneys, doctors, etc., then you're not going to be able to enter into contract without that license. Contracts that are contrary to public policy, such as a restraint of trade, are generally void. However, a covenant not to compete could be enforceable if its geographic terms are reasonable and the duration of time is reasonable. A contract may not be enforced if it's procedurally unconscionable, meaning it has inconspicuous or small print or difficult legalese. It would depend on the party's lack of knowledge. And there's also substantive unconscionability, where the terms or conditions surrounding the contract are oppressive or overly harsh, don't provide a party with any remedy whatsoever. The court may not enforce it. And exculpatory clauses are clauses that release a party from liability in the event of some kind of injury, regardless of who it's fault. The court will enforce them if it's not contrary to public policy, not ambiguous, and doesn't shield the party from intentional conduct. So if there was a clause that said you could escape liability even if you committed some intentional act against someone else, the courts generally won't enforce those. As we said earlier, illegal contracts are void. Neither party would be able to collect or recover in that situation. There are some situations where the court has granted a remedy if there was some justifiable ignorance of fact on an innocent party's behalf, if one of the parties was part of a protected class, if there was a chance to withdraw from an illegal agreement, if part of the contract which was illegal could be severed from the legal part, or the contract was entered into under fraud, duress, or undue influence. Mistake could allow a party to avoid a contract. We're talking about a mistake of fact, not value, not paying too much for something. If it's a unilateral mistake, generally the courts won't allow that party to get out of the contract unless the other party knew they were making that mistake or it was something like a typo. However, courts do allow the parties to back out if there's a bilateral or mutual mistake. This would be basically the parties not agreeing to the same thing as a result of a mistake. Fraudulent misrepresentation may make a contract voidable by the innocent party. It requires misrepresentation of a material fact, an intent to deceive, a reliance on that misrepresentation, and an injury to the innocent party. These are different ways that you could have a misrepresentation of material fact. It could be how the parties acted. It could be an expert opinion. Typically, opinions by others would not be actionable. It could be by law or by silence even. The party could fail to disclose something that they have a duty to disclose. For example, if they have a fiduciary relationship and they fail to disclose material facts. The intent to deceive is required. Person does it, makes the fraudulent misrepresentation knowing the fact is not true, or is reckless in their statements about it. The other party, the deceived party, must justifiably rely on their representation. If they knew it not to be true, that wouldn't be justifiable. And there has to be an actual injury. So you could say something that's not true, and if the other party relied on it but wasn't injured, that wouldn't be fraudulent misrepresentation. However, no proof of injury is required when the action is to rescind the contract, so if you're just asking to back out. Undue influence is when there's a special relationship between the parties. In that situation, the contract would lack voluntary consent and would be voidable. Example might be attorney-client, guardian-ward. It's presumed that the weaker party would be talked into doing something that wasn't beneficial to him or herself. Duress would be physically forcing or threatening physical force. That would make the contract voidable. Threat of civil suit or not getting a good deal, economic duress generally isn't sufficient. In some cases, another defense to enforceability is the form that the contract is. Some contracts required to be in writing and signed by the party against whom you're going to enforce it. Here are this is the statute of frauds, basically. Here are the 5 areas: contracts involving the interest in land, the 1-year rule, collateral or secondary contracts, promises made in consideration of marriage, and contracts for the sale of goods priced at $500 or more. So when we say interest in land, we would mean land contract, leases, sale of land. The 1 year basically says a contract that cannot, by its terms, be performed within 1 year need to be in writing. Collateral or secondary contracts means co-signing. A co-signature should be in writing unless the purpose of the oral guarantee to pay the debt of someone else is to benefit yourself. Prenuptial agreements, promises made in contemplation of marriage, and contracts for sale of good price at $500 or more. So if you were to look at a quiz question and it was talking about an oral agreement for more than that, then the statute of frauds would require it to be in writing. There are some exceptions. The idea is that you wouldn't have anything to prove that there was an agreement. However, you could substitute that with partial performance. Maybe somebody's already shipped goods, the other party's paid part of it. An admission that there is an agreement in court. Promissory estoppel, which we talked about before, basically the idea that although the whole agreement isn't in writing, but there was a promise the other party justifiably relied on, and other special exceptions under the UCC. The writing doesn't have to be too complex. It just could be a written memorandum or electronic signed by the party against whom enforcement is sought. Could be a fax, could be an email. Basically just has to have the essential terms. Quantity needs to be in there. We mentioned signature of the party against who you're trying to enforce it, who the parties are, what the contract's about, the subject matter, and what consideration is being exchanged. In the sale of land, it needs to state the price and description with sufficient clarity.